Want to learn more about following too close tickets in the state of Washington? Stay tuned and learn more. All right, and like I said in the intro, today we are talking about following too close tickets in Washington State. Now, this information is only applicable to Washington State. So if you have a following too close ticket in another state, I would encourage you to reach out to a local traffic ticket attorney local to your state. But jumping back into it, let's get going. Following too close. It's a type of ticket that we traditionally see in an accident ticket, specifically in accidents that involve rear end collisions. So what does the law say? RCW 46.61.145 requires that a driver shall not follow another vehicle more closely than is reasonable and prudent, having due regard for the speed of such vehicles and the traffic upon and the condition of the highway. I know that sounds like a whole lot of legal jargon, but what does it actually mean? Boiling it down, it means that when you're driving behind the vehicle in front of you, the primary duty of avoiding an accident is on you. Now, I routinely get calls from drivers who say they had a safe following distance and the vehicle in front of them slammed on their brakes. Unfortunately, you would likely still be at fault because it is a well-established rule that in the absence of an emergency, the following driver is typically at fault. Even if there was an emergency though, you may still be at fault if the emergency is an ordinary traffic condition or one that you should have anticipated. So someone slamming on their brakes in front of you for traffic, that would be something that you should have anticipated. However, if the person cut you off and then slammed on their brakes and you were not able to stop in time, you'd have a better argument there because technically you were not following that vehicle until they cut you off. Kind of boiling it down, the main points are the prosecutor or city needs to establish what is reasonable and prudent considering the speed of traffic and the condition of the roadway. The problem is reasonable and prudent is not defined and it's very subjective. So now that we know what the law says, let's address what you should do about it. A following too close ticket in Washington State is considered a moving violation and it will go on your driving record. Unfortunately, this ticket can lead to a double dip hit on your insurance rates if your insurance company counts them as separate events, meaning your rates take a hit for the accident and then for having the moving violation on your driving record in addition to the accident. Therefore, in most circumstances, it makes sense to contest these types of traffic tickets. Now you may be thinking to yourself, well, I was clearly at fault, what's the point? The point is, even if you were at fault, the prosecutor still has to prove it. I routinely get following too close tickets dismissed for my clients. Accident tickets can be very challenging to prove for the prosecutor if they can't produce a witness at the contested hearing because the only information they have comes from the officer's report. The problem there is that the officer, one, didn't witness the infraction and probably didn't do much of an investigation as to what actually happened. Also, without the witness, the majority of the officer's report becomes hearsay. And if it's hearsay, it would not be admissible at your contested hearing. Wrapping it up, if you have a following too close ticket in Washington State and you'd like to discuss your options more, feel free to give us a call at 253-201-2001 or find us online at MrTicketFixer.com.